"Get off our property," the HOA president was shouting, finger pointed at my chest. Behind her, 2 board members and the third cop of the day. They thought they had me cornered. I'd just closed on this land 2 weeks ago. 2 acres, 1 old lake, all mine. But they'd been running it like their personal playground for decades. The officer stepped forward, hand on his belt. That's when I opened my laptop. What I showed him made the board members go silent. They'd called the cops on me, but this time I wasn't the one breaking the law. Ever dealt with people who thought they owned you? By the time the third cop showed up, I already knew the script. "Sir, you need to stop what you're doing here," he said, gesturing toward the old lake I'd just bought. "The HOA says you're building without authorization." I turned my laptop screen toward him. "This is code 33 CFR 329.4 from the Army Corps of Engineers. This lake connects to the federal waterway system through an underground culvert. Installed in 1947. The HOA has no jurisdiction here." He squinted at the screen. The 2 HOA board members standing behind him went pale. I hadn't told them about the hydraulic survey map I'd found last night. What would you do if you discovered the organization controlling you never had the legal right to do so? Let me back up 6 hours. I'm Quincy Dalton, and I'd just closed on 2 acres of land with a 0.8-acre lake in suburban Georgia for $85,000. The price seemed too good to be true, but I'd spent 11 years as a land surveyor and title examiner, specializing in boundary disputes. I knew how to trace ownership chains back through decades of county records. This property was mine. Clean and clear. No easements, no covenants, no strings attached. The lake was old, needed work, but it was exactly what I wanted after my mother passed and left me enough to finally buy some peace. I arrived at the property that first morning with my surveying equipment, ready to map the exact boundaries and assess what restoration the lake would need. The water sat still and dark, surrounded by overgrown cattails and wild grass. I was setting up my transit when 3 people approached from the neighboring subdivision. A woman in her early 50s led the group, walking with the kind of confidence that comes from years of unchallenged authority. 2 men flanked her, one of them carrying a thick binder. "Excuse me," the woman said, not bothering with introductions. "I'm Margot Sinclair, president of the Meadowbrook Homeowners Association. This lake is community property. You need to review our lake maintenance regulations before you do anything here." She gestured to the man with the binder. "Clayton has copies of all 47 rules you'll need to follow." Clayton stepped forward, his expression skeptical as he looked me over. The third board member, an older man who introduced himself as Philip, the treasurer, hung back slightly, looking uncomfortable. I kept my voice level. "I appreciate you coming by, but I've reviewed the deed thoroughly. This lake is part of my private property. It's not listed in any HOA covenant or common area designation." Margot's smile didn't reach her eyes. "We've managed this lake for 20 years. Everyone in the neighborhood knows it belongs to the community. Your deed must be wrong." I pulled out my phone and showed her the recorded deed with the county stamp, clearly visible. "This is from the county clerk's office. The lake is within my property boundaries. There's no easement granting access to anyone else." Clayton's tone sharpened. "Are you sure you understand what you're reading? What do you do for a living?" The question hung in the air, with an edge I recognized immediately. I'd dealt with people like him before, people who assumed I didn't know what I was talking about the moment they saw me. I kept my response professional. "I'm a land surveyor and title examiner. I've been doing boundary disputes and ownership research for 11 years. Margot cut in before Clayton could respond. "This is community property. If you continue claiming otherwise, we'll have no choice but to contact the authorities about trespassing." I took out my phone and started photographing. First, the private property sign I'd installed that morning, clearly visible with GPS coordinates burned into the image metadata. Second, my deed with the county seal and recording date. Third, the 3 of them standing on my land making threats. "I'm documenting this conversation," I said calmly. "You're welcome to review your own HOA, but you'll find no mention of this lake because it's never been part of your association." Philip shifted uncomfortably. "Margot, maybe we should check the original covenants before," she cut him off with a sharp look. "We'll be in touch," she said, turning away. Clayton lingered a moment longer, his eyes narrowed, before following her back toward the subdivision. I watched them go, then checked my watch. 10:17 in the morning. My phone rang at 11:30. The local police department, responding to a report of someone trespassing on community property. The officer was polite, professional. Gravel crunched under his boots as he walked the perimeter with me. Sunlight caught the ripples on the lake surface behind us while I laid out the documentation, the deed, the survey, the title insurance, the recorded plat map. He radioed his supervisor, who spent 15 minutes on his computer in the patrol car. Red and blue lights reflecting faintly off the water. When he returned, his tone had shifted to neutral bureaucracy. "Sir, you're the legal owner. I'm noting that in my report. Try to work this out with your neighbors if you can." The second call came at 1:45. Different officers, same complaints, same documents, same conclusions. The third arrived at 4:30. Each time I added notes to my file timestamps, badge numbers, dispatch recordings if available. By evening, the pattern was unmistakable. 3 separate 911 calls in 6 hours. All from the same complainant, all claiming I was trespassing on HOA property. I had officers' names and badge numbers. I had GPS-stamped photographs. I had email confirmation that the HOA had sent for threatening messages to the address listed on my deed within 48 hours of my purchase. This wasn't confusion. This was coordinated intimidation. They'd done this before, I was certain. The question now was how long they'd been doing it, who else they'd targeted, and what documentation I'd need to prove it wasn't just about me. Because if there was one thing 11 years of title work had taught me, it was this: when someone claims authority they don't legally possess, there's always a paper trail showing exactly when they started lying. That evening, I sat on the tailgate of my truck and watched the light fade. The temperature dropped with the sun, and the lake went still, in that quiet way it does right before full dark. Somewhere in that stillness was the reason I'd bought this place. My mother used to say that land was the only thing no one could take from you if you knew how to hold on to it. She died 6 months ago, leaving me just enough to prove her right. I'd spent 11 years tracking down the truth about property people thought they owned but legally didn't. The work taught me that the law protects people who do their homework and punishes those who assume good faith is enough. My job was finding what was buried in courthouse basements, then making it so clear a judge had no choice but to rule on facts. One case taught me everything I needed to know about water and jurisdiction. 2 landowners in rural Alabama had been fighting over a creek for years, each claiming the other was stealing water. I found a culvert system installed by the Civilian Conservation Corps in the 1930s that connected the creek to a navigable river. The moment I saw that stamp on the blueprint, the fight was over. Federal jurisdiction. The Corps of Engineers controlled the water, not the landowners. Case dismissed. That experience stuck with me. Water doesn't care about property lines, and neither does the federal government. If a lake or creek connects to a navigable waterway, it falls under the Clean Water Act. Local governments can zone the land around it, but they can't override federal control of the water itself. Most people don't know that. Most HOAs definitely don't. When I first toured this property 3 months ago, something about the lake looked off. The shape was irregular, like 2 ponds had merged over time. The eastern edge narrowed into a shallow channel that disappeared into willows and sediment. It reminded me of old drainage features I'd seen on farm services, the kind that get abandoned and swallowed by growth. I'd flagged it as worth investigating. But the title came back so clean that I moved forward anyway. The Meadowbrook HOA covenants, recorded in 1995, didn't mention the lake at all. That silence should have told me something was wrong. I pulled up the historical records. The lake had started as a mill pond in the 1880s, a reservoir for a grist mill, long since gone. Then in 1947, the Army Corps of Engineers issued a dredging permit and installed a culvert connecting the pond to Sweetwater Creek. Sweetwater fed into the Chattahoochee River, a navigable waterway under federal protection. That culvert was still there, hidden under silt and decades of neglect, which meant this wasn't just a pond on private land. It was part of the waters of the United States, a designation, with consequences Margot clearly didn't understand. Unseen connections shape everything. The Alabama case had taught me that. This one would prove it again. I saved the documents to 3 separate drives and printed hard copies. If the HOA wanted documentation, I'd give them more than they could argue with. They had no authority here. They never had. Whether they knew that and were lying or genuinely believed their own story after 20 years, the outcome would be the same. Tomorrow, I'd start building the case that would end this quickly and cleanly. At least that was the plan. Something told me Margot Sinclair wasn't the type to accept facts quietly. The next morning, I waded into the eastern edge of the lake with chest waders and a soil probe. The water was cold, thick with algae and decades of sediment. It took 40 minutes of probing through mud before the steel rod hit something solid. I cleared away layers of silt with my hands and found it a concrete pipe 36 inches in diameter, angled downward into the lake bed. Water moved through it, a slow current I could feel at the opening. This wasn't a relic. It was still functioning, still connecting this lake to Sweetwater Creek, a quarter-mile east. I pulled out my phone and photographed the culvert from multiple angles, making sure the GPS coordinates were embedded in the metadata. I measured the diameter, noted the depth below the waterline, and sketched the surrounding vegetation. Then I climbed back to shore and opened my laptop to confirm what I'd just found. The regulation I needed was Title 33 of the Code of Federal Regulations, Section 329.4. It defines waters of the United States, any water body with a physical connection to a navigable waterway, including connections through culverts, ditches, or subsurface flow falls under the jurisdiction of the Army Corps of Engineers and the Environmental Protection Agency. It doesn't matter if the connection is obvious or hidden. It doesn't matter if the water body sits on private land. If the connection exists, federal authority applies. I pulled up the U.S. topographic map from 1947. The map showed Sweetwater Creek running parallel to the lake's eastern boundary, with a notation indicating engineered drainage infrastructure. I traced the likely underground path of the culvert from the lake to the creek, roughly 1,300 feet, passing beneath what was now part of the Meadowbrook subdivision. Then I searched the National Archives database. 20 minutes later, I found it. Permit DR 1952, issued March 14, 1952, authorizing maintenance, dredging of the mill pond, and inspection of the culvert system connecting it to Sweetwater Creek. That permit was the keystone. It proved the Corps had recognized this lake as part of their jurisdiction 73 years ago. This lake was, legally speaking, a federal waterway. Margot Sinclair had no more right to regulate it than she did to pass zoning laws for the Atlantic Ocean. I downloaded the permit, the USGS map, and the CFR regulation. Then I opened the HOA covenants for Meadowbrook and read through 38 pages of rules. No mention of the lake, not one reference to water management, shoreline access, or maintenance. The covenants defined HOA jurisdiction, and those boundaries stopped at the property lines of the subdivision lots. My land had never been part of Meadowbrook. The lake had never been common property. I sat back and let the full picture settle. For 20 years, the HOA had been collecting fees from homeowners under the premise that they were maintaining a community lake. They'd been enforcing rules they had no legal standing to create. Every fine they'd levied, every rule they'd passed, every fee they'd collected was built on a foundation that didn't exist. Whether they knew it or not, they'd been running a system with no legal basis. And now I had the documentation to prove it. The question was what they'd do when I showed them, and whether they'd accept the truth or double down on the lie. I spent the next 2 days building what I called the evidence binder, a comprehensive file that would answer every question before it was asked. I'd learned from years of courtroom depositions that the side with better organization usually won, not because their case was stronger, but because they made it easier for judges to rule in their favor. The binder had 6 tabs. Tab 1 contained the culvert photographs with times, GPS coordinates, and a hand-drawn diagram showing its position relative to the lake and the underground path to Sweetwater Creek. Tab 2 held the historical documentation, the USGS map from 1947, and the Army Corps permit from 1952, both with certified copies from the National Archives. Tab 3 was the legal framework, the full text of Title 33, CFR Section 329.4, with a plain language summary I'd written explaining that connected lakes fall under federal jurisdiction, plus a flowchart showing the chain of authority. Tab 4 contained my property documents, the deed, survey, title insurance, and the legal description from the original land grant proving the lake had always been part of this parcel. Tab 5 covered the HOA itself, the Meadowbrook covenants with highlighted sections showing the lake was never mentioned, plus a plat map with HOA boundaries in red and my property in blue, making the separation visually obvious. Tab 6 was the incident log, 3 911 calls with officer names and badge numbers, 4 emails from Margot Sinclair, and screenshots of the HOA website incorrectly showing the lake as community property. I made 3 copies of the complete binder. 1 stayed with me, 1 went into a fireproof safe at my bank, and 1 was uploaded to a cloud server with redundant backups. If the HOA wanted to escalate, I was ready. If they wanted to negotiate, I had everything we'd need. And if they wanted to pretend none of this existed, I had enough documentation to make that impossible. The next move was theirs, but I'd already mapped out every possible response. I sent an email to the HOA board 3 days after completing the binder. The subject line was simple: request for meeting regarding lake jurisdiction. The body was 2 sentences. I have documentation concerning the legal status of the lake on my property that I believe the board should review. Please let me know when you are available to meet. Margot responded within an hour, suggesting the following Tuesday at 7 o'clock in the evening at the subdivision's community center. I arrived 10 minutes early with my laptop and the evidence binder. 5 people sat around a folding table, Margot Sinclair in the center, flanked by Philip the treasurer and 3 other board members, including Clayton. I set the portfolio on the table and took the empty chair across from them. Thank you for meeting with me, I said. I wanted to clarify the legal situation before this goes any further. Margot's expression was polite but firm. There's no confusion on our end. That lake has been maintained by this HOA for 2 decades. The community has always treated it as shared property. I opened the laptop and turned the screen toward them. This lake is connected to Sweetwater Creek by an engineered culvert from the 1940s. That creek feeds into the Chattahoochee River, a navigable waterway under federal protection. That connection makes this lake part of the waters of the United States, which means the Army Corps of Engineers has jurisdiction, not local control or HOA authority. Philip leaned forward. What does that mean exactly? I clicked to the next slide, showing Title 33, CFR, Section 329.4. It means your HOA can't regulate this water body. I have the original Corps permit from 1952 proving they recognized jurisdiction. I opened the binder to tab 5 and slid it across the table. This is your HOA covenant from 1995. The lake isn't listed anywhere. Philip picked up the binder and flipped through the highlighted pages, his face shifting to concern. Margot, I don't see the lake mentioned. She didn't look at him. I pulled up the plat map showing subdivision boundaries in red and my property in blue. The map on your website shows the lake inside HOA boundaries, but the recorded plat from the county shows it outside. My deed includes the lake. There's no easement granting you access. Clayton spoke, his voice edged with skepticism. You're sure you're reading these documents correctly? What's your background in this kind of work? I kept my tone even. I'm a land surveyor and title examiner. I've been resolving boundary disputes and researching property ownership for 11 years. If you'd like a second opinion, you're welcome to hire your own surveyor. They'll tell you the same thing. Margot cut in. We've invested resources in maintaining it. We've collected fees to cover those costs. If you continue making these claims, we'll pursue legal action for interference with HOA operations. I closed the laptop. I'm not making claims. I'm presenting facts. The lake is on my deed. It's not in your covenants. It's connected to a federal waterway. If you pursue legal action, you'll be asking a judge to override federal jurisdiction and ignore recorded property documents. Philip looked uncomfortable. Do we have liability insurance for the lake? I've been asking about that for months. Margot's jaw tightened. We have general liability coverage, Philip pressed. But specific coverage for a body of water. She cut him off. This conversation is premature. We need to consult our attorney. I stood, gathering my materials. I'd recommend you also request documentation showing when and how the HOA acquired legal authority over the lake. If that documentation exists, I'd like to see it. If it doesn't, we need to discuss how to move forward without further conflict. I handed Margot a business card. I'll be submitting this information to the Army Corps of Engineers and the county within the next 2 weeks to clarify jurisdiction formally. The silence that followed was thick and unresolved. Margot's expression was unreadable, but her hands were clenched on the table. Philip looked caught between relief and dread. Clayton's posture was rigid, his eyes following me with barely concealed hostility. I'd given them a chance to step back quietly. Whether they took it would determine everything that came next. 2 nights after the board meeting, I received an email from an address I didn't recognize. The subject line read, "You should know what's really going on." The message was brief. I'm a neighbor who's lived here 26 years. I know the truth about that lake. Can we meet somewhere private? I replied with the time and the address of a coffee shop 3 miles outside the subdivision. The woman who walked in the next afternoon was in her early 60s, with gray hair pulled back and the cautious posture of someone who had spent years keeping quiet. I am Beatrice Navarro, she said, sitting across from me. I've been watching what's happening with your property, and I think you need to know how this started. The lake wasn't always managed by the HOA, she said. In 2003, it belonged to an elderly man named Harper, who lived alone. When he died, his kids were out of state and didn't know what to do with the property. Margot called a board meeting and proposed that the HOA assume management. She said it would be a community asset. Most people didn't ask questions. They just voted yes. I leaned forward. Was there any legal transfer of ownership? Beatrice shook her head. Not that I ever saw. Margot just started collecting fees. $120 per household per year. With 180 homes, that's over $21,000 annually. We've been paying for it for 20 years. That's over $400,000, and no one's ever seen a detailed accounting of where it went. I pulled out a notepad. Did anyone ever question it? Her expression darkened. A few tried. They got threatened with fines or letters from the HOA's lawyer accusing them of harassment. After a while, people stopped asking. She reached into her bag and pulled out a manila folder. Inside was a photocopy of board meeting minutes from October 2003. The relevant section was brief. Motion to assume management of Community Lake approved unanimously. No mention of legal authority. No reference to ownership transfer. Beneath the minutes was a handwritten list of names. These are 12 households who have been fined, threatened, or intimidated for asking questions, Beatrice said. I can't promise they'll all talk to you, but they might if they know someone's finally standing up to Margot. I photographed the minutes and the list with my phone. Are you willing to go on record with this if it becomes necessary? She nodded. Georgia is a one-party consent state. If you need to record a conversation and I'm part of it, you don't need anyone else's permission. I'll do what I can to help. I thanked her and watched her leave. The folder now in my possession. What had started as a property dispute was becoming something larger. Margot hadn't just overstepped her authority, she'd built a system that relied on intimidation, and it had been running unchallenged for 2 decades. That was about to change. The HOA bylaws included a provision I'd flagged during my initial review. Any 10% of members in good standing could petition for a special meeting to address matters of community concern. I drafted a 1-page request, citing concerns about lake jurisdiction and financial transparency, then contacted Beatrice. Within 4 days, she and 21 other homeowners had signed. I submitted the petition to the board by certified mail. Margot had no choice but to schedule the meeting. She set it for 3 weeks, out the maximum delay allowed under the bylaws and reserved the community center for 7 in the evening on a Thursday. I spent those 3 weeks preparing a presentation that would be impossible to dismiss. 15 minutes of facts, no rhetoric, no personal attacks. I borrowed a projector from a colleague and tested it twice to make sure the images would be sharp and legible from the back of the room. I printed handouts summarizing the key points to federal jurisdiction issue, the absence of the lake from HOA covenants, and the 2-decade collection of fees without transparent accounting. I rehearsed the presentation until I could deliver it in my sleep, anticipating every question and objection. The night of the meeting, I arrived early. The community center parking lot was already half full. Cars angling into spaces under streetlights that cast long shadows across the asphalt. Inside, rows of folding chairs faced a table at the front where the 5 board members would sit. I set up the projector on a cart near the back wall, connected my laptop, and tested the display. The screen came to life with the title slide, Lake Jurisdiction and Financial Accountability. People began filtering in, some curious, some wary, some clearly aligned with Margot based on the way they greeted her when she entered. By 7, nearly 100 people filled the room. The air was warm and close, the kind of atmosphere where tension builds quickly. Margot called the meeting to order, her voice carrying authority even as she introduced the reason for the gathering. This special meeting was requested to address questions about the lake adjacent to our community. We'll hear from the petitioner, and then the board will respond. She gestured toward me without warmth. I stood, connected my laptop to the projector, and walked to the front of the room. Thank you for being here. I began. My name is Quincy Dalton. I recently purchased the property that includes the lake, some of you have been told is community property. I'm here tonight to share information that I believe everyone in this neighborhood deserves to know. I clicked to the first slide showing the USGS map from 1947. This lake was connected to Sweetwater Creek in the 1940s through an underground culvert. Sweetwater Creek feeds into the Chattahoochee River, which is a navigable waterway under federal law, specifically Title 33 of the Code of Federal Regulations. That connection places this lake under the jurisdiction of the Army Corps of Engineers, not local or HOA authority. I clicked to the next slide showing the text of the regulation with the key phrase highlighted. This means the HOA has never had the legal standing to regulate the lake. It's not a matter of opinion. It's a matter of federal jurisdiction. Murmurs rippled through the room. I let them settle before continuing. The second issue is ownership. I've reviewed the Meadowbrook HOA covenants, which were recorded in 1995. The lake is not mentioned anywhere in those documents. It's not listed as a common area. It's not part of the HOA's legal jurisdiction. I displayed the plat map showing the subdivision boundaries in red and my property in blue, the separation unmistakable. Despite this, the HOA has been collecting a lake maintenance fee from homeowners for the past 20 years, at $120 per household per year, with 180 homes. That's $21,600 annually. Over 20 years, that totals approximately $432,000. The room went quiet. I paused, letting the number land. I'd like to ask the board a simple question. Where did that money go? Margot's expression hardened. We've used those funds for exactly what we said we would. Landscaping around the lake, water quality testing, general maintenance, insurance. I kept my tone neutral. Can you provide documentation, contracts with landscaping companies, invoices for water testing, a copy of the insurance policy covering the lake? She hesitated. Those records are maintained by the board. I'd have to pull them together. I nodded. I'd appreciate that, because I haven't been able to find any public record of how those funds were spent. And if the HOA is collecting fees for a property it doesn't legally control, that's a significant issue. Philip spoke up from his seat at the board table, his voice uncertain. Margot, I've been asking to see the lake insurance policy for months. You said you'd send it to me. The room's attention shifted to him. He looked uncomfortable but continued. I've never actually seen a separate policy for the lake. Our general liability covers the community center and common areas, but I don't know if it covers a body of water. Margot's jaw tightened. We've had coverage. I just need to locate the paperwork. A man in his late 70s stood from the third row, leaning on a cane. I recognized him from Beatrice's description. Mr. Harland, one of the original residents. I've lived here since 1998, he said, his voice steady despite his age. That lake belonged to Mr. Harper when I moved in. It was his property. The HOA had nothing to do with it. After he died, Margot told us the association should take over managing it, that it would benefit the community. I don't remember anyone voting on whether we actually had the legal right to do that. We just voted to manage it, and that was that. The murmurs grew louder. I saw people leaning toward each other, whispering. A woman near the front raised her hand. If we've been paying for something the HOA doesn't own, can we get that money back? Another voice from the side. Why weren't we told the lake wasn't actually ours? I raised my hand to quiet the room. I'm not here to assign blame. I'm here to clarify the facts. The lake is on my property. It's under federal jurisdiction. The HOA doesn't have authority to regulate it or collect fees for its maintenance. What happens next should be a community decision, but it needs to be based on accurate information. Margot stood, her voice sharp. This is a coordinated attack on the board's authority. We've managed this community responsibly for years. One person with a grievance shouldn't be allowed to undermine everything we've built. I've met her eyes. This isn't about grievances. It's about jurisdiction and documentation. If the board has records showing legal authority over the lake, I'd welcome seeing them. If those records don't exist, then we need to acknowledge that and figure out how to move forward honestly. Philip cleared his throat. I think we should request an independent audit of the Lake Maintenance Fund. If we've been collecting fees, we should be able to show exactly how they were spent. A younger woman near the back stood. I second that. Margot's face flushed. An audit is expensive and unnecessary. Philip's voice was firmer now. If we have nothing to hide, it shouldn't be a problem. The room erupted in conversation, people calling out support for the audit, others demanding to see the insurance policy, a few defending Margot out of loyalty or habit. I let the noise build for a moment, then spoke loud enough to cut through it. I'd like to propose a vote. All those in favor of requesting an independent financial audit of the Lake Maintenance Fund, please raise your hands. Hands went up across the room. I counted quickly, estimating 70 or more out of 100. All opposed. Fewer than 20 hands rose. The rest abstained, uncertain or unwilling to commit. The community has spoken, I said. An audit should move forward. Margot gathered her papers, her movements stiff with barely controlled anger. This meeting is adjourned. She left the table and walked toward the exit, Clayton following close behind. Philip stayed seated, looking exhausted and relieved at the same time. People began standing, some approaching me with questions, others clustering in small groups to discuss what they'd just heard. Beatrice caught my eye from across the room and nodded once, a gesture of quiet solidarity. I packed up the projector and my laptop, fielding questions as I worked. Yes, I'd submit the federal jurisdiction information to the Corps of Engineers. Yes, I'd be willing to share documentation with anyone who wanted to review it. No, I wasn't trying to take anything from the community. I just wanted clarity about what belonged to whom and who had the authority to make decisions about it. By the time I left, the parking lot was nearly empty. The night air was cool and still. I sat in my truck for a moment, reviewing what had just happened. The community had shifted. Margot's authority had cracked. The question now was how she'd respond when the pressure increased to mornings after the community meeting. I drove out to the property to check on the survey markers I'd placed along the boundary line. The gate at the entrance to my access road was open. The chain I'd secured it with was lying in the gravel, cut cleanly through the middle. The lock was missing. I stopped the truck and got out, photographing the severed chain and the gate hanging at an awkward angle. The cuts were fresh, the metal still bright where the bolt cutters had sheared through. I walked up the road toward the lake, scanning for other damage. The private property sign I had installed near the waterline had been spray-painted a crude red slash across the words with the letters "Thief" scrawled beneath it. I took multiple photos from different angles, making sure the timestamp and GPS data were embedded in each image. Then I noticed the truck. The driver's side panel had a long, deliberate scratch running from the front fender to the rear quarter panel, deep enough to reach the primer. It hadn't been there yesterday. I called the non-emergency line for the county sheriff's office and waited. A deputy arrived 30 minutes later, a young woman with a notebook and a body camera clipped to her vest. I walked her through what I'd found, showing her the chain, the gate, the sign, and the truck. She took her own photographs and filled out an incident report, her pen moving steadily across the page. "Any idea who might have done this?" she asked. I hesitated, then told her about the HOA dispute, the community meeting 2 nights ago, and the escalating tension. She nodded, writing it all down. "We'll increase patrols in the area. If you have security cameras, now would be a good time to install them." I drove into town that afternoon and bought 4 wireless cameras with cloud backup and motion detection. By evening, they were mounted at key points around the property. One covering the gate, one aimed at the private property sign, one overlooking the truck's usual parking spot, and one facing the lake from the eastern shore. Each camera fed to an app on my phone, storing footage automatically to a remote server. If someone came back, I'd have a record. The footage came sooner than I expected. At 11:43 that night, the motion sensor on the gate camera triggered an alert. I opened the app and watched a white pickup truck roll slowly past the entrance, pause for several seconds, then continue down the road. The license plate was partially obscured by mud, but the make and model were clear. I'd seen that truck before. It belonged to Clayton. The camera at the sign captured him 20 minutes later, standing just outside my property line, staring toward the lake. He didn't cross onto my land, but the intent was obvious. He was testing the boundaries, seeing what he could get away with. I saved the footage and created a new folder on my laptop labeled Harassment Documentation. Inside, I compiled everything: the photos of the damaged gate and sign, the scratch on my truck, the deputy's incident report number, and the video of Clayton's truck. I sent copies to the sheriff's office with a formal complaint, attaching the footage and requesting follow-up. Then I drafted an email to the Army Corps of Engineers, Atlanta District, and another to the EPA region for office. The subject line for both was the same: request for jurisdictional determination and notification of dispute. The emails were concise. I explained that I owned property containing a lake connected to a navigable waterway through a culvert installed in 1947. I noted that a local homeowners association had been asserting regulatory authority over the lake without legal standing, and that the dispute had escalated to intimidation and property damage. I requested formal confirmation of federal jurisdiction and guidance on next steps. I attached the USGS maps, the 1952 Corps permit, and the relevant sections of Title 33 CFR. Then I hit send on both messages. The automatic replies came within minutes. The Corps estimated a response within 15 business days. The EPA's turnaround was similar. I filed the confirmations in the evidence binder and updated my timeline. The situation was no longer just a local property dispute. It was now a matter of federal record, documented and escalated to the agencies with actual authority. Margot could threaten all she wanted. Clayton could drive by and glare. But the machinery of federal oversight was already in motion, and once it started, it didn't stop until the jurisdictional questions were answered. I locked the gate with a heavier chain and a padlock designed to resist cutting. Then I went inside, checked the camera feeds one more time, and waited to see who would make the next move. 10 days after I sent the emails, my phone rang with a number I didn't recognize. The area code was local. I answered, "Mr. Dalton, this is Delia Brennan from the Army Corps of Engineers, Atlanta Regulatory Division. I'm calling about the jurisdictional determination request you submitted." Her voice was professional. Clipped. "We've reviewed your documentation. You're correct. The lake on your property falls under waters of the United States due to its connection to Sweetwater Creek. Be sending a cease and desist letter to the Homeowners Association, informing them they have no regulatory authority over the water body." I felt the tension I'd been carrying for weeks ease slightly. "How long will that take?" She paused, and I heard papers rustling. "The letter will go out within 48 hours. We're also opening a compliance review to determine whether any unpermitted activities have occurred. If the HOA has been discharging materials into the lake, fertilizers, herbicides, anything that affects water quality, that's a potential Clean Water Act violation. We'll need to inspect the site." I gave her directions to the property and confirmed my availability. She said someone would be in touch within the week. The call from the county came 2 days later. The attorney's office had received complaints from 15 homeowners requesting an audit of HOA finances. County code required HOAs to maintain transparent records and provide annual financial statements to members. The Meadowbrook Association had filed the minimum required disclosures, but those disclosures didn't itemize the lake maintenance fund separately. The county was now requiring the board to produce detailed documentation, 5 years of financial records, itemized expenditures for lake-related costs, and proof of liability insurance. They had 30 days to comply. I met with the county's HOA liaison 3 weeks later in a conference room that smelled of old carpet and burnt coffee. She was a woman in her 40s with reading glasses on a chain and a binder thick enough to double as a doorstop. "We've completed the preliminary review," she said, sliding a summary sheet across the table. "The findings are concerning." She walked me through the numbers. Over the past 5 years, the HOA had collected $108,000 in lake maintenance fees. Of that amount, only $12,000 could be documented with invoices payments to a landscaping company for mowing the grass around the lake perimeter twice a year. The remaining $96,000 had been dispersed through checks, labeled general maintenance or operational expenses. Most of them were written to cash or to vendors that couldn't be verified. One check stood out, $85,000 paid in 2019 to a limited liability company called Lakeview Services. The county had cross-referenced the business address. It matched Margot Sinclair's home address. The LLC had been registered 3 months before the check was issued and dissolved 6 months after. No services were ever documented. No invoices existed. "That's embezzlement," I said. The liaison nodded. "It appears that way. We've referred the matter to the district attorney's office. They'll determine whether to pursue criminal charges." She flipped to another page. "There's also the issue of insurance. The HOA claimed to carry liability coverage for the lake, but we found no policy on file with any insurer. The general liability policy for the association explicitly excludes bodies of water. If someone had drowned or been injured at that lake, the HOA would have had no coverage. Every homeowner who paid into that fund was exposed to liability without knowing it." She closed the binder. "The board will be required to refund all lake maintenance fees collected since 2003. That's approximately $432,000 divided among the households that paid. We're also recommending the HOA be placed under receivership until a new board can be elected and proper financial controls established. I asked what that meant. A court-appointed receiver will take over financial operations temporarily. The current board will be suspended from decision-making authority until the situation is resolved. 2 days later, the EPA called. They'd sent an inspector to the lake and taken water samples. The results showed elevated phosphate levels consistent with herbicide runoff. The HOA had hired a lawn care company in 2018 to spray weeds around the lake. The company's records, subpoenaed by the EPA, showed they'd applied a restricted-use herbicide without the required National Pollutant Discharge Elimination System permit. That was a direct violation of the Clean Water Act. The EPA was issuing a notice of violation to the HOA as an entity, with fines starting at $45,000 if the board members had knowingly authorized unpermitted chemical application. Individual penalties could follow. I sat at my kitchen table that evening and updated the timeline I'd been keeping. The pattern was clear. Margot had taken control of something she didn't own, collected money without accountability, created a shell company to funnel funds, and authorized environmental violations without proper permits. She'd intimidated anyone who questioned her and built a system that relied on people being too afraid or too tired to dig into the details. But systems like that only work when no one checks the foundation. I'd checked, and the foundation was gone. The district attorney's office issued a statement a week later. Margot Sinclair was under investigation for embezzlement and filing false documents. The exact charges would depend on the evidence, but the potential sentence ranged from 5 to 10 years if convicted, plus restitution of all misappropriated funds. Clayton faced misdemeanor charges for vandalism and harassment based on the camera footage I'd provided. Philip, the treasurer, had been granted immunity in exchange for his cooperation. He'd admitted that Margot controlled all financial decisions and that he'd signed documents without being allowed to review supporting records. The pieces were falling into place, each one a consequence of choices Margot had made years ago. The federal government had jurisdiction. The county had evidence of fraud. The community had demanded accountability. And I had documentation of every step. What had started as a property dispute had become a case study in what happens when small authority goes unchecked for too long. 6 weeks after the community meeting, the consequences arrived in waves. The first was Margot Sinclair's arrest. I learned about it from a neighbor who sent me a link to the county's online booking records. The charges were listed in plain language: embezzlement, filing false documents, and fraud. The bail was set at $50,000. She posted it within 24 hours. And was released pending trial. The mugshot showed a woman who looked smaller than I remembered, her expression vacant and tired. I felt no satisfaction looking at it, only a kind of weary recognition that accountability had finally caught up. Clayton's charges came through the magistrate court a week later: vandalism and criminal trespass, both misdemeanors. The security footage I'd provided was clear enough that his attorney advised him to plead no contest. The judge sentenced him to a $2,500 fine, 100 hours of community service, and a restraining order prohibiting him from coming within 500 feet of my property. I received the court order by certified mail. I filed it with the rest of the documentation and moved on. The county's decision on the HOA came in the form of a court order appointing a receiver. The board was suspended from all financial and operational decision-making authority. A forensic accountant was brought in to review every transaction dating back to 2003. The goal was to trace the $432,000 in lake fees and determine how much could be recovered. Homeowners would receive refunds proportional to what they'd paid over the years, minus administrative costs. The average household would get back around $2,400. It wasn't full restitution, but it was something. The EPA's penalty was straightforward. The Metal Homeowners Association, as a legal entity, was fined $45,000 for violating the Clean Water Act by authorizing unpermitted herbicide discharge into a federally regulated water body. The fine was assessed against the association's general fund, which meant it would come out of the reserves that were supposed to cover road maintenance and emergency repairs. The new receiver would have to figure out how to pay it without bankrupting the community. That wasn't my problem, but I felt for the homeowners who'd had nothing to do with Margot's decisions and were now paying the price. Philip, the former treasurer, sent me an email 3 weeks after the receiver took over. It was brief and apologetic. He explained that he'd been intimidated by Margot for years, that he'd signed checks and approved budgets without understanding what he was authorizing. He admitted he should have pushed harder, asked more questions, and refused to go along with things that didn't feel right. The immunity deal he'd accepted required him to testify if the case went to trial. He said he was relieved, in a strange way, that the truth was finally out. I replied with 2 sentences: "I appreciate you coming forward. The community deserves leadership that earns trust instead of demanding it." The receivership process took 4 months. During that time, the forensic accountant identified several additional irregularities: payments to vendors who didn't exist, reimbursements for expenses that were never documented, and a pattern of dual signatures on checks where Philip's signature had been forged. That last finding cleared him of any remaining suspicion and added another charge to Margot's growing list. The district attorney was building a case that would be difficult to defend against. Her attorney was already negotiating a plea deal. The community held a special election to replace the suspended board. Beatrice Navarro ran for president and won by a significant margin. Her platform was simple: transparency, accountability, and a return to the basics of what an HOA should do: maintain common areas, not expand its reach into places it had no legal authority. She asked me to attend the first meeting of the new board, not as a participant, but as a resource. I agreed. The meeting was short and focused. Beatrice presented a revised set of bylaws that explicitly removed any reference to the lake and clarified the boundaries of HOA jurisdiction. The board voted unanimously to adopt them. The refund checks went out in early spring. Each household that had paid lake maintenance fees received a mailing with a breakdown of what they'd paid, what had been recovered, and what their refund amount was. The accompanying letter, signed by Beatrice and the receiver, explained what had happened and apologized for the years of mismanagement. It was a small gesture, but it mattered. People wanted to know that someone acknowledged the problem and was trying to fix it. I watched all of this unfold from a distance, checking in occasionally, but mostly letting the system do what it was designed to do. My role had been to identify the problem and provide the documentation that made accountability possible. The rest was up to the courts, the county, and the community itself. Margot would face sentencing later in the year. Clayton had completed his community service and stayed away from my property. The lake was quiet again, the water still and undisturbed. The federal government had confirmed its jurisdiction. The HOA had been restructured, and the people who'd been taken advantage of were finally getting answers. It wasn't a perfect resolution, but it was a real one, built on facts and consequences that couldn't be argued away. 3 months after the receiver took control of the I started the process of regularizing the lake's status with the federal government. The Army Corps of Engineers had confirmed jurisdiction, but that didn't mean I could do whatever I wanted with the water. Any work that affected the lake's connection to the navigable waterway system required permits. I wasn't looking to avoid oversight. I was looking to do things correctly from the start, the way they should have been done decades ago. I contacted the Corps and asked about restoration options. The representative I spoke with suggested applying for a nationwide permit 27, which covers aquatic habitat, restoration, and enhancement projects. The permit would allow me to dredge accumulated sediment, repair the culvert to improve water flow, and install native vegetation along the shoreline to reduce erosion and filter runoff. The application required detailed plans, environmental impact assessments, and proof that the work would improve water quality rather than degrade it. I hired an environmental consulting firm that specialized in wetland and lake restoration. They spent 2 weeks surveying the site, taking water samples, and mapping the sediment depth. Their report was thorough. The lake had accumulated nearly 3 feet of organic material and silt over the past 70 years. The culvert, while still functional, was partially blocked, reducing the flow between the lake and Sweetwater Creek. Water quality was poor, with elevated phosphate levels from the herbicide application in 2018 and low dissolved oxygen from decomposing plant matter. The lake could support aquatic life, but it would require intervention. The firm drafted a restoration plan with 3 phases spread over 3 years. Phase 1 involved dredging the lake to remove contaminated sediment and restore the original depth. The cost was estimated at $15,000, including disposal of the dredged material at an approved site. Phase 2 focused on repairing and expanding the culvert to increase water exchange with the creek, improving circulation and oxygen levels. That would cost around $8,000. Phase 3 called for planting native species along the shoreline, creating a buffer zone that would filter runoff and provide habitat for fish and amphibians. The plants would be sourced from a local nursery specializing in native ecosystems. Cost $3,000. I submitted the application to the Corps with a restoration plan, environmental assessment, and letters of support from the county and the new HOA board. Beatrice had written one on behalf of the community, explaining that the neighborhood supported responsible stewardship of the lake and appreciated efforts to restore it as a healthy ecosystem. The Corps approved the permit 6 weeks later with 2 conditions. I had to establish a vegetative buffer zone at least 20 feet wide around the entire shoreline, and I had to submit annual water quality reports for the first 5 years to document the restoration's effectiveness. I accepted the conditions and started Phase 1. That summer, a small dredging crew spent 3 weeks removing sediment, working carefully to avoid disturbing the culvert or damaging the existing shoreline. The lake's water level dropped temporarily as they worked, revealing the true extent of the buildup. When they finished, the lake was nearly 2 feet deeper than it had been, with clean sand and gravel visible along the bottom near the eastern edge. The water clarity improved within days as suspended particles settled, and the increased flow from the creek flushed out stagnant zones. Phase 2 began in early fall. A contractor excavated the area around the culvert and replaced the aging concrete pipe with a larger, more durable structure designed to handle higher flow volumes. The new culvert included a grate to prevent debris from blocking the passage while still allowing fish and other aquatic life to move freely between the lake and the creek. The work took 2 weeks and was completed without incident. The difference was immediate. Water moved through the system faster, and the lake surface showed ripples and currents that hadn't existed before. Phase 3 stretched into the following spring. I worked with a landscape crew to plant native grasses, sedges, and shrubs along the entire perimeter. We installed erosion control fabric to hold the soil in place while the roots established. By summer, the buffer zone was thriving, attracting dragonflies, frogs, and songbirds. I stocked the lake with bluegill and largemouth bass from a state-certified hatchery species that were native to the region and would help control insect populations and establish a balanced food web. I also created something I called the Lake Stewardship Fund, a simple website where neighbors or anyone interested in supporting the lake's ongoing maintenance could donate voluntarily. The site included photos documenting the restoration, water quality test results, and a transparent ledger showing how every dollar was spent. There were no mandatory fees, no assessments, no obligations. People gave because they wanted to, not because someone was threatening them with fines. In the first year, the fund raised $6,000, enough to cover annual water testing, buffer zone maintenance, and a small emergency reserve. The county noticed. A representative from the planning department reached out and asked if I'd be willing to present the restoration project at a workshop on private landowner compliance with federal waterway regulations. They wanted to use it as a case study and example of how to work within the system rather than against it. I agreed. The workshop was held on a Saturday morning at the county offices. About 30 people attended, a mix of landowners, HOA board members, and local officials. I walked them through the process, identifying the jurisdictional issue, documenting the facts, working with federal agencies, and obtaining the proper permits. The questions afterward were practical and focused, the kind that told me people were genuinely trying to understand how to avoid the mistakes Meadowbrook had made. Beatrice attended the workshop and thanked me afterward. She said the community was in a better place now that people trusted the new board and felt like they had a voice again. The lake, she said, had become a symbol of what was possible when someone refused to accept things as they were and insisted on finding out what they should be. I told her I'd just done what anyone with the right training and a bit of stubbornness would do. She smiled and said that was exactly the problem. Most people didn't have the training, and even fewer had the stubbornness. That's why it mattered. A year after the restoration work finished, I stood at the edge of the lake on a cool morning when the water reflected the sky like polished glass. The shoreline vegetation had filled in, dense and green. A great blue heron stood motionless in the reeds. The water was clear enough to see bluegill moving in schools near the drop-off. The house I'd built sat 50 yards back, a small structure with large windows facing east to catch the morning light. It was exactly what I'd imagined when I bought the land, a place where I could wake up to stillness. My mother would have liked it. The community had changed too. Beatrice ran the HOA with a steady hand, focused on transparency and basic road maintenance, upkeep, and open financial reporting. The mandatory lake fees were gone, replaced by the voluntary stewardship fund that people contributed to because they wanted the lake to thrive. Trust, I'd learned, was something you built through consistency, not demands. Clayton had finished his community service and stayed away. He'd written a letter months after his sentencing, apologizing for the vandalism and admitting that anger and prejudice had clouded his judgment. I'd written back 2 sentences. I accept your apology. I hope you've learned something from this. I wasn't carrying any resentment. Holding on to anger would have only hurt me. Margot's case had concluded with a plea agreement, 3 years in prison, 5 years probation, and full restitution of the embezzled funds. The restitution would take years to collect, but the court had made it clear she wouldn't walk away without paying back what she'd taken. I didn't take any pleasure in her downfall, but I didn't feel sorry for her either. The lake had become a gathering place. Beatrice organized a community fishing day in the spring. I volunteered to help, teaching children how to bait a hook and cast a line, watching them pull in bluegill and release them back into the water. Their faces lit with excitement reminded me why any of this had mattered. It wasn't just about property rights or legal jurisdiction. It was about creating something better than what had been there before. Received an email from the Army Corps of Engineers in late summer, asking if I'd serve as a volunteer advisor for their public education program on waterway, jurisdiction, and landowner responsibilities. I accepted. The water quality reports I submitted each year showed steady improvement, phosphate levels normal, dissolved oxygen healthy, fish population stable, and reproducing naturally. The lake wasn't just surviving, it was thriving. I sat on the small dock I'd built that spring, my feet dangling over the water, and thought about everything that had happened. All of it had started because I'd asked a simple question: who actually has authority here? That question had unraveled 20 years of assumptions and revealed a system built on nothing but repetition and intimidation. The answer had required patience, evidence, and a willingness to let the process run its course. My mother used to say that knowledge was the one thing no one could take from you. She was right, but knowledge alone wasn't enough. You had to be willing to use it to stand up when things were wrong, and to trust that the truth would hold up under scrutiny if you documented it carefully enough. Finally, peace. And it was legal. Thanks for watching HOA Havoc. Share this video with someone who loves a good plot twist.